In this video, we will discuss some Philippine labor laws that employers must know, and of course, you as an employee should definitely know too. The next 8 minutes will completely change your perspective about discrimination in the workplace. Here's how we'll do it. We'll discuss the facts of the case for you to have a clear context, the main issue that needs to be resolved, and the ruling of the Supreme Court, which you definitely need to hear. Let's dive right in, shall we? Nestled in the heart of the community, St.Scholastica's College West Grove, SSCW, stands as a unique blend of Catholic tradition and non-sectarian ideals, a place where education and faith converge. It was in May of 2001 that Cheryll Leus, eager and determined, stepped into the institution as an assistant to Sister Edna Quiambao, the esteemed director of the Lay Apostolate and Community Outreach Directorate. Little did she know, this seemingly routine start would lead her into a journey that would test her in ways she could never have imagined. Sometime in 2003, she conceived a child out of wedlock with her boyfriend as the father. When SSCW found out about this, Sister Edna advised her to file a resignation letter effective June 1st, 2003. Cheryll stood firm and said that she would not do so, but eventually she was directed to explain in writing why she should not be dismissed for her actions. And so she wrote in her letter that she was not aware of the school policy that getting pregnant out of wedlock is considered as a serious misconduct and a ground for dismissal, and even requested for a copy of SSCW's policy and guidelines. However, Sister Edna responded that since their support staff handbook has yet to be enacted, they follow the 1992 Manual of Regulations for Private Schools, or the MRPS, and that Section 94E cites disgraceful or immoral conduct as a ground for dismissal in addition to those provided under Article 282 of the Labor Code. Cheryl's counsel argued through a letter that premarital sex between two consenting adults without legal impediment to marry each other, and later on marries each other, does not fall within the meaning of disgraceful or immoral. But the Council of SSCW argued that it is, and that SSCW as a Catholic institution has the right to uphold Catholic teachings and expect its employees to abide by it. Moreover, Cheryl's act is further aggravated by the fact that she is the assistant to the director of the Lay Apostolate and Community Outreach Directorate, a position of responsibility that the students look up to as role model. After these exchanges, Cheryll was officially terminated on June 11, 2003, and she filed a case through her counsel with the Labor Tribunal, where both parties rigorously argued their respective sides. The labor arbiter ruled against Cheryll, stating that there was a valid ground for her dismissal, and pointed out that as an employee of a Catholic institution, she is expected to live up to the Catholic values taught by SSCW. Her act should not be taken in isolation, but should be analyzed in light of the surrounding circumstances as a whole. It was committed in an environment where strict adherence to the values required and where the reputation of the school is at stake. Cheryll appealed to the National Labor Relations Commission, NLRC, which affirmed the ruling of the LA, adding that the dismissal was well within the scope of Section 94E of the 1992 MRPS. Thereafter, even on appeal to the Court of Appeals, her petition was denied, and thus her last resort in fighting for her rights is to finally bring the case to the Supreme Court. The main issue to be resolved here is whether or not Cheryl's pregnancy out of wedlock constitutes as a valid ground to terminate her employment. The Supreme Court ruled that for an act to be labeled as immoral, it is not the totality of the circumstances surrounding the conduct per se that determines whether it is disgraceful or immoral, but the conduct that is generally accepted by society as respectable or moral. Clear evidence must be provided to show that a certain behavior, based on common societal standards, is seen as shameful or improper. Thus, the determination of whether a conduct is disgraceful or immoral involves a two-step process. First, a consideration of the totality of the circumstances surrounding the conduct, and second, an assessment of the said circumstances in relation to the prevailing norms of conduct, i.e., what the society generally considers moral and respectable. The fact that Cheryll worked for a Catholic school does not automatically mean her pregnancy out of wedlock is shameful or improper. It is still necessary to assess whether her situation is considered unacceptable based on common societal standards. Also, it is important to emphasize that public and secular morality should determine the prevailing norms of conduct, not religious morality. This distinction between public and secular morality and religious morality is important because the jurisdiction of the court extends only to public and secular morality. If the government bases public policies and morals on religious beliefs, those policies would force people to follow standards rooted in religion. This would compel non-believers to adhere to rules shaped by religious principles they may not share. Broad religious freedom means the government must stay neutral about religion. Relying on religious reasons for government actions goes against this neutrality. The government can only make laws against things that hurt society. These laws can't be based on what a single religion believes is wrong. For example, the government can't outlaw something just because a religion says it's a sin. Now, to emphasize, when the law talks about morality, it refers to public and secular standards, not religious ones. So, the rule against disgraceful or immoral conduct in Section 94E of the 1992 MRPS as a reason for dismissal must also follow public and secular morality. For a behavior to be considered disgraceful or immoral, it must harm or threaten the conditions needed for society to exist and progress, not simply because a specific religion disapproves of it. But in a case where the dismissal of a teacher involved an extramarital affair with his co-teacher, who is likewise married, the court did not hesitate to rule that it was both disgraceful and immoral, because it violates the sanctity of marriage. The case of Cheryll, however, is different. It is important to emphasize that premarital sexual relations between two consenting adults who have no legal impediment to marry each other, and consequently conceiving a child out of wedlock, gauged from a purely public and secular view of morality, does not amount to a disgraceful or immoral conduct under Section 94E of the 1992 MRPS. Further, Cheryll's dismissal is not a valid exercise of SSCW's management prerogative. As explained earlier, her actions are not considered disgraceful or immoral by law. Moreover, Sister Edna admitted that at the time of the issue, SSCW did not have any rule or policy against employees engaging in premarital sexual relations or becoming pregnant as a result. Since there is no legal or policy basis for her dismissal, SSCW's decision was unfair and arbitrary, and therefore not a valid exercise of management prerogative. In sum, the court found that Cheryll was illegally dismissed as there was no just cause for the termination of her employment. SSCW failed to provide substantial evidence to establish that engaging in premarital sexual relations and conceiving a child out of wedlock, assessed in light of the prevailing norms of conduct, is considered disgraceful or immoral. And so, the story comes to a close with a resounding victory, not just for Cheryll, but for fairness, for dignity, and for the principles that remind us all of what is right. This decision is more than just a legal outcome. It's a beacon for anyone who has ever faced injustice and dared to hope for a better tomorrow. Thank you for joining us on this journey. Until next time, stay curious, stay informed, and don't forget to subscribe for more legal recaps.